Do you have a copy of the paper that I signed waiving my right to speedy trial?
The court has that. It's noted on the memorandum of snap-outs and stuff. Waive speedy trial. Continue.
Okay. On May 2nd, 2012.
You don't have to sign for it, by the way.
On May 2nd, 2012, that was my 175th day into this case. If you count from November 7th, 2011 to May 2nd, 2012, that's 175 days in. The state had a duty to bring me to trial on that day. Instead, my case was continued due to lack of depositions. Valentine refused to come in for depositions. And it kept getting continued and continued because she would not come in for depositions.
Okay.
So what do you as an attorney do at that point when the only witness that claims, that she's a victim states, and you have a 911 recording with her yelling, cursing, insinuating and lying and mentioning a weapon with 911 operator? What do you at that point do? She is supposed to be the victim. She's supposed to have a 3-inch cut on her forehead. That's what she told the detective. What do you at that point do? When you get the police report and it says it's 3 centimeters laceration, which is not a cut, and it's not even 1 inch. What do you do 6 months into this case, and well over 6 months, 8 months into this case? What do you do when your client is asking you for a speedy trial?
It's very difficult for me to put myself in a position where I wasn't. 4 years ago, I was not your attorney, okay? Someone else was your attorney. Someone else wanted to do depositions. Someone else didn't follow through with those depositions and do a rule to show cause. Okay, that would be the natural thing.
Okay, so then let me ask you the question another way. If the victim in the case refuses to come forward for deposition, if they refuse to talk to you on the phone, let's say they just hang up the phone. Let's say you come to their door, you subpoena them. And they refuse, they tell you at your door, I'm not coming in. Close the case. I don't want to prosecute.
That's not going to happen that way.
So,
if you allow me to finish, I'll describe to you what the bad thing that's going to happen.
How do you can't predict the future. I don't want you to give me predictions. I want you to give me what you do if that were to occur.
I wouldn't do that at all. But
you wouldn't do what at all?
Ma'am, you got to allow me to answer your question, okay?
But you said you wouldn't do that, so you have to clarify. That's all I'm asking.
I'm not going to talk if you talk over me. Okay? I wasn't your attorney 4 years ago. I wouldn't have handled the case the way it was handled 4 years ago in the first place. The same thing I'm doing right now is the same thing I would have been doing back then, potentially, which is to make sure you had options, to make sure that we didn't lock a witness into a certain testimony. Okay, we didn't badger a witness that didn't want to cooperate. The next thing that you do if the witness doesn't show up for a deposition is you do a rule to show cause with the court. You ask the court to find her in contempt of court because you received the lawful summons to appear for a deposition. The next thing that happens is the court will grant that motion. The court will issue its own subpoena for Ms. Valentine to appear in court. If Ms. Valentine doesn't appear in court on the judge's subpoena, the next thing the court will do is issue a warrant for her arrest. She will then be locked up in jail, and she will appear because she will have an invitation and transportation from the sheriff's office to testify in your case, and a very good reason to say a whole bunch of stuff that a jury would hear and potentially use to convict you. Okay? On the other hand, if she just naturally doesn't appear, and the state attorney has her own difficulty in getting her, that inures to your benefit.
Okay, thank you. Now my next thing is the Fifth Amendment. Are you stating that she does not have the right to the Fifth Amendment?
Yeah, that's correct.
She does or she does not?
She does not.
Why would she lose that right?
Because it doesn't apply to her. It applies to you because you've been charged with a crime, okay? So you're a target of an investigation. It doesn't, let's say again, your friend Nisha is...
So you're telling me that she called, wait.
No, I'm leaving right now. I'm going to get a drink of water because my voice is leaving. But I'm going to answer your question, okay? And I'm not going to answer any other questions until I answer this question. First, I'm going to get a drink. I'll be right back.